because he referred to them in his testimony. He had them in his possession. Now, there's been no evidence elicited in this case that Eric Menendez had any knowledge of those letters, that he saw them, that he had them. There's no indication that Dr. Burgess ever relied on them or referred to them. And our position is that people should be prohibited from asking any questions about them, particularly since I am only calling Dr. Burgess back to talk about this tape, not to reopen my original presentation of her. And in any event, our position is that with respect to Eric Menendez, those letters were violative of the discovery rules, and there's been no waiver of that by any testimony on his part.
Well, those letters were voluntarily turned over by the defendant, Lyle Menendez, and offered by the defendant, Lyle Menendez, is my recollection.
Because
and their purpose was to deal with their concern regarding certain arguments that might be made during closing argument.
Well, they were facing an instruction about withholding evidence that we're not facing because my client never said anything to anybody about.
All right. Well, whatever the reason is, whatever privilege there was or any right of privacy there was, it was that of Lyle Menendez, and he has voluntarily turned those documents over. So the defendant, Eric Menendez, has no claims of discovery or otherwise that have been violated here.
Well, they're hearsay. They've never been.
Okay, those are separate arguments.
All right, we'll make that argument. Then we'll make the separate arguments that they are hearsay. That there's no indication that he had knowledge of them. There's no indication that Dr. Burgess relied on them in any way, shape, or form, and it's hard to see the relevance of them at this stage in any event.
What is it that people wanted to do with them?
Well, Your Honor, I wanted to question her about those letters. We didn't have them in our possession previously. No, wait, we did have them. She testified afterwards. Your Honor, the letters should be in front of the Eric Menendez jury for the simple reason that although they may be hearsay, they go to the state of mind of Mrs. Menendez. And one way to do that is to present them through the testimony of Dr. Burgess. Another way would be to have Detective Zoller somehow mention them in rebuttal. But it's the people's position that those letters from Mrs. Menendez, however we obtained from many statements of the parents, have been admitted over the people's objection under the state of mind exception to the hearsay rule. And for that reason, I feel that these letters, which are further statements of Mrs. Menendez, should be in front of both juries.
Well,
that may well be true, and I don't rule on it one way or the other. I really haven't focused on it since this is really the first you brought to my attention. But it would seem, potentially at least, that it would be beyond the scope of the examination of Dr. Burgess today if her testimony is limited to certain specific things, that this would be beyond the scope of that examination.
Your Honor, there's one mistake. First of all, the letter 316 is a letter to Lester Summerfield, so to that extent that needs to be clarified. But in the December 11th tape, there's reference to a suicide letter by Eric Menendez in the beginning part, and contained within either 312 and 315 is a letter which I think could be construed by a rational. To that extent, I think that we should be allowed to question her about that particular letter.
Well, Your Honor, there's no record here that that's the particular suicide letter that my client found. And in fact, I think the testimony is contrary. If not, I would make an offer of proof that the letter that he found was destroyed and was destroyed by his grandmother. And I think that testimony, in fact, did come out. There is no evidence that any of these letters are the letter that he is talking about. And even if there were, well, I mean, there is no evidence that that's the letter.
Let me stop. If I don't know exactly how the defense is going to examine Dr. Burgess, but if the area touches upon the mother's state of mind or issues relating to letters that she might have left and things that she might have done that caused any of these statements to be made on the tape, or that might have influenced the defendant's state of mind at the time the tape recording was made or at the time of the killing of the parents, then these letters might very well be relevant. So I don't know where you're going to go with the examination.
Well, I'm not sure what the court is saying, because clearly the content of the tape, there is a tremendous amount of discussion, 90% of the discussion by Lyle Menendez, and to a lesser extent by Eric Menendez, and to a large extent by Dr. Oziel, has to do with Mrs. Menendez's misery and grief, and the notion that she was killed as a form of euthanasia. Now, I can't avoid the fact that Dr. Burgess she's going to analyze this tape, so she's going to have to refer to the content of what's being said. But it is not our intention for her to refer to outside information, to say, yes, I know because Eric Menendez told me that the mother really was in this kind of state.
Well,
Although even if she did, he's testified to that. She knows that because he testified to that or told her that.
As I said, I don't know exactly what she's going to say, but if she says something that relates to going beyond the words on the tape to impressions she has formed about the mother and the mother's psychology, then these tapes or these letters could be relevant to that.
All right.
Test her responses.
It's not my intention to ask her to do an analysis of the mother or the father based on, at this stage, that's already been done in the case. What she's going to is this tape and what's going on between the three people on this tape, and what are the things that Eric Menendez is saying that support her opinion, and what are the things that Lyle Menendez is saying that support her opinion, what are the things that Dr. Oziel is saying and doing that support her opinion. And so she's staying within the contents of the tape. She's not going to offer, for example, she's not going to say, well, here Eric is talking about his mother doing this and that, and in my opinion, the mother was this, that, or the other thing. That's not what we're planning to do. She's already done that. I mean, that happened in another phase of the expert testimony.
Yeah. Well, as I said, without knowing exactly what she will say, her testimony will not be, but I don't know exactly what it will be. And until I hear it, I can't make a final ruling on it. But there's certainly a potential that, depending on how she says things, that these letters could have some relevance. I do have in mind that these letters were available during her examination and they weren't used by the prosecution, and that this is a potentially and hopefully brief episode of her testimony that will not open the door to re-examination on all matters that counsel forgot to discuss with her before, and that the scope of her direct examination will control the scope of the cross-examination. That's as far as I can go until I hear the specifics. Let's go to the other issue, and that has to do with the position of Lyle Menendez as to whether her testimony should be before his jury.
Judge, as the court knows, our original position with respect to Dr. Burgess was that she should testify in front of our jury on all issues, and we raised with the court the issue of whether the prosecution would be entitled to cross-examine her about the Calabasas burglary. And we indicated at the time this issue was litigated before that we felt forced to have Dr. Burgess in front of our jury because Eric Menendez's testimony had been thrust on us by the court's ruling. The court at that point, when this issue was raised, indicated that the burglary would be a proper subject to cross-examination. And so in light of the fact that the burglary had not otherwise been disclosed, Lyle Menendez decided not to have this witness testify in front of his jury. But what she did testify to in front of the jury was her crime scene analysis and also the testimony about the physiological effects of fear. And she indicated with respect to the crime scene analysis that she was looking at the crime scene primarily, but that she did upgrade her crime scene analysis to take into account more information. And she specifically referred to the testimony of neighbors. And she also, at one point, refers to the testimony of Lyle and Eric Menendez concerning their admission to being the shooters and their awareness of the police letting them come in and remove ammunition from the car after the killings took place. So there was reference in the direct testimony to fact-specific things in the in the testimony. And then the thrust of the cross-examination was that she had, in fact, concentrated too much on the crime scene and had not taken into account things which developed after the crime, such as testimony, and would include any other evidence which could possibly contradict her opinion. And then her testimony with respect to the physiological effects of fear was general in nature, but she also made it quite clear that the effects she was describing were effects which were shared by all people. And she also testified in general about the effects of trauma and specifically child abuse. In the abstract, her testimony doesn't relate to Lyle Menendez, but viewed in conjunction with the other evidence in the case, the only relevance of having her testify about the effects of child abuse in front of our jury and the physiological effects of fear was so that we could use her testimony to bolster our theory of defense here, that what happened was a result of child abuse. So at this point, Lyle Menendez's defense team feels that we need to call Dr. Burgess to confront her with the December 11th tape. And we also feel that the risk that we're worried about, that is the disclosure of the burglary, has been rendered moot by the court's ruling that the December 11th tape would come into evidence. That tape, of course, does contain reference to the burglary. The burglary was explored with Dr. Conti. And Dr. Burgess can add something at this point. First of all, she can testify to her evaluation of Eric Menendez, similar to what she testified to in front of the Eric Menendez jury alone. We would be seeking to elicit from her, in general, the same testimony that was elicited in front of Eric Menendez. Facts that they cross-examined her about in front of the Eric Menendez jury alone. And in addition, even if that did not take place, we still think her testimony concerning her evaluation of the tape is relevant because the tape contains not only the voice of Lyle Menendez, but also statements by Eric Menendez. And unlike Dr. Conti, who did not evaluate Eric Menendez, Dr. Burgess is in a unique position to explain Eric Menendez's statements on that tape. And so I don't feel her testimony would be cumulative.
And the people's response.
Your Honor, the people are asking the court to limit the number of expert witnesses allowed to testify as to this particular piece of evidence under Evidence Code Section 723. Moreover, her testimony in front of both juries in the direct examination was not case specific, and the reason I cited the page that I cited is because the colloquy we had at the sidebar indicates that. Now, the fact that neighbors testified is still limited to crime scene because the neighbors are only testifying as to noise emanating from the crime scene, so I don't think that's a particularly persuasive argument. And as to the fact that she was cross-examined somewhat about other evidence that was still generic in nature, the people are concerned that this particular type of testimony is but insofar as Dr. Conte has already testified for Lyle Menendez, it appears that he has had the benefit of that kind of expert testimony and should not now be able to selectively pick one piece of evidence, which is case specific, and have Dr. Burgess explain it away. It's not that the people are threatening to do a full and complete cross-examination and take a day, but rather the people feel it might be necessary to do that simply because if we're now going to get case specific in front of the Lyle Menendez jury, that would require us to be thoroughly case specific and not focus on simply the December 11th tape. So because of the fact that the court has discretion to limit the number of expert witnesses, because Lyle examination of Dr. Burgess in front of the Lyle Menendez jury.
But she did offer her opinion on case-specific issues here. She said that, in her opinion, there was a high degree of emotion involved in this crime. And of course, an interpretation of the December 11th tape would contradict that. She also testified that the randomness of the injuries indicated to her a wider range of emotions than just anger or rage, and in fact indicated that the killings were motivated by fear. So she is very case specific on her analysis of the crime scene. And what we don't want to be is in a position of having her not take into account something which we feel becomes important to the jury's evaluation of the case, that is the December 11th tape.
Well, what you're proposing is basically for her to repeat all of the testimony that she gave in relationship to the evaluation of Eric Menendez, to repeat that in front of the Lyle Menendez jury. You had that opportunity earlier, and you did not take advantage of it. And she's now being called for a limited purpose relating to the specifics of Eric Menendez. The court did review the testimony that she gave before both juries, and her testimony was not case specific in that she did not evaluate the testimony of all the witnesses and all the facts provided in that testimony and all witnesses' statements in order to form any opinions. Whatever opinion she expressed dealt with the crime scene itself and her opinions about it, and based on the photographs, the coroner's reports, and things of that nature. And there was some cross-examination by the prosecution that went into matters such as whether purchase of weapons days before would have any impact on her opinion, and some other questions along those lines. But basically, her testimony was not case specific, and she was specifically asked at page 18,004 by Ms. Abramson, "It's not your role here to comment on all the evidence in this case and decide whether this was or was not a planned crime, is it?" Answer: "That's true." Question: "You're here to analyze the crime scene." Answer: "Yes." And that was the initial thrust of her testimony, and that was introduced without objection. I've told you that I had reservations about the admissibility of those opinions, but they came in without objection by the prosecution. The next phase of her testimony had to do with an evaluation of, in general, again, the physical effects of fear and fight-flight reactions and things of that nature. And she described them in a general sense, how people behave and react. And that was before both juries. And then the Lyle Menendez jury left for a couple of days, is my recollection, while the Eric Menendez jury heard Dr. Burgess testify at great length, both on direct and cross-examination about all the materials that she considered, not just the interviews with the defendant, which was 40 plus hours or 60 plus hours, but all sorts of other information that she had accumulated in relationship to any opinions she expressed. And that was all related to Eric Menendez and any opinions that she formed in relationship to his mental or emotional condition that she then expressed for the jury. That was only before the Eric Menendez jury. And at this point, your proposal is to go through all that again and ask her all about those things, which did take about 2 days, perhaps even longer. She was on the witness stand a good period of time. We had to call off the Lyle Menendez jury once, and they came back, and we had to send them home. And it took quite a bit of time before her testimony was completed, all before the Eric Menendez jury. And basically what you're proposing now is that because you elected not to do it earlier, you want to do it now and have all that evidence come out at this stage repetitively. And number one, it would be repetitively in front of the Eric Menendez jury. And then secondly, if they for some reason decided, well, they would volunteer that their jury not be in the courtroom during that, then we'd have a repeat of all that evidence before the Lyle Menendez jury that could have been done all at once. All because you want to ask this witness whether, having heard the tape of December 11th, her opinions regarding whether the crime scene was planned or unplanned would change.
Could I address the court's concern? First of all, I think it's, just in terms of arguing this, it's proper to look at two offers of proof being made here. One is whether Dr. Burgess should be allowed to testify to what she testified to in front of the Eric Menendez jury alone. And that's being offered now because the situation has changed in light of the court's ruling on the December 11th tape. It is not repetitious to offer that evidence in front of the Lyle Menendez jury because obviously they haven't heard it yet. It would not be offered in front of the Eric Menendez jury, but in front of the Lyle Menendez jury. It's not repetitious at all because none of that evidence was presented to the jury. Theoretically, the court makes reference, well, we had the opportunity to present it in front of both juries, and our response to that is that practically was not the case because at the point in time when that evidence was offered, there was a certain situation in the evidence which made it so that the burglary had not been disclosed in front of our jury, but had been disclosed in front of the Eric Menendez jury. And so it wasn't, well, we had a choice and we could have gone forward at that point. In fact, it would have been incompetence on our part had we done so and had the burglary disclosed. But then the facts change, as is often the case in a trial. So now we're no longer in the position where that tactical factor weighs heavily against calling her. And we have not yet rested. We're still in our case in chief. It is not a question of the court deciding whether or not this is proper rebuttal or not. The facts have changed. And so the one issue is whether the Lyle Menendez team would be entitled to call her in front of their jury alone on the issues that were explored in front of the Eric Menendez jury. Putting that aside, the second issue is if the court did not allow that and excluded that entirely under 352 or some other analysis, should Dr. Burgess be entitled to comment in front of our jury on the December 11th tape? And it's our position that on that narrow issue, she should be because she is in a unique position to evaluate, especially Eric Menendez's role and participation in that tape and the statements that he makes on that tape. And Dr. Conti cannot do that effectively because he has never evaluated Eric Menendez. It does not require detailed exploration into why she evaluated Eric Menendez in order for the people to effectively cross-examine her on the narrow issue of her interpretation of the December 11th tape. But without that interpretation, she is vulnerable in front of our jury to the criticism that she narrowly focused on the crime scene and did not take into account what undoubtedly will be offered by the prosecution as the most important, or one of the most important items of evidence.
That's not absolutely not true. That argument, she would be vulnerable, and I suppose that people would argue that she didn't consider the statements of Lyle Menendez or Eric Menendez at all when she expressed those opinions. And that's the way this case would have ended if this December 11th tape hadn't been introduced. That she, as far as your jury is concerned, expressed some opinions about the physical evidence and about flight reactions, and in expressing those opinions, she didn't consider the statements and the evidence of the defendants, other than the fact that she said she was presented with it, but the jury doesn't know all the details of what it was, and she was already examined about it. So that still would have been the situation. I don't see how that changes. This is just one piece of evidence. I suppose we could go through the entire trial, and every time another piece of evidence is introduced, call the experts back and ask them, would you change your opinion about something because of what has been introduced?
Well, we could in a hypothetical situation, but that's not what the defense is doing. We're asking her to focus on one particular piece of evidence, which in our mind needs to be focused on at this point.
Okay.
And we're not offering to bring her back to explain every fact in the case.
Yes, I don't want to minimize the nature of the evidence. I appreciate your concern about the evidence of the tape recording and how you want to react to it. But again, your proposal is to ask her the type of question that would then open her examination to everything that she says or did say or testify about that related to Eric Menendez. And everything that was encompassed in her testimony, which was, as I said, a couple days long, outside of your jury's presence.
I think the court can handle that situation through Evidence Code Section 352. I don't think it's a situation where the people would be entitled to cross-examine her for days on any and all statements that Eric Menendez made to her when she's going to be testifying on a narrow issue concerning her interpretation of the December 11th tape.
Well, what is she saying? What is she, just give me a preview of what is it you expect her to say about it.
Well, if we can focus on that portion of the tape when Eric Menendez gets to say a few words, which is basically the second half, I think she's going to say that Eric's emotionality and some of the things that he is saying here corroborate her opinion that this was a crime based on fear, that he loved his parents, as he expresses here, with appropriate affect, just as he testified, and both juries heard that testimony. And that he told Dr. Oziel that he loved his parents, which contradicts Dr. Oziel's testimony. I think that she will say, she will say some things that are similar to some extent to what Dr. Conti said about the tape, but when it comes to talking about Eric Menendez, she's going to talk about the fact that he is saying things that corroborate what he told her, corroborates his testimony. I don't think she'll say corroborates his testimony because that's argumentative, but that it's consistent with what he told her. The way he expresses himself in talking about his parents is consistent with what he told her and consistent with her conclusion that he acted out of fear and in self-defense. That's basically what she's going to say. What she's not going to get into, because there's nothing in this tape that would lead her to get into it, is her analysis of his molestation history. Or this doesn't bear, at least not directly, so I wasn't going to elicit it. This doesn't bear on her opinion that, in fact, he was sexually molested by his father for 12 years in the ways that he's described it. Even though he has described all that in front of the Lauman and his jury, this tape doesn't link to that. What she will say did not tell Oziel about the molestation history. And that's, of course, no surprise because that's been obvious since the beginning of the case. So, I mean, basically, that's what she's talking about, how this tape and what Eric is saying and the way that he's reacting to what Oziel is doing is consistent with a number of the issues that have been presented. His genuine guilt, his genuine remorse, his sadness and loss of his parents, his emotional attachment to them, his feelings about them, his attachment to his brother. The fact that the story that's being told here is nuts, to use a non-technical word, cannot have been the real reason, in her opinion, that the real reasons are constantly hinted at here, that sort of thing. It really is totally focused on the nature of the crime and not on the psychological history component of her testimony.
Well, it's however derived from what Eric Menendez told her and others told her that was disclosed just to his jury.
No, Your Honor, it was not disclosed just to his jury. Everything that's corroborated here is what Eric Menendez testified to. The reason I wouldn't ask it in terms of testifying is because that always brings out an objection argumentative and a sustained one. I will limit it that way if that's a clearer way to understand it. But she has read all of his testimony, and she has reread his testimony to analyze this tape, just as she has read all of Lyle Menendez's testimony and all of Dr. Oziel's testimony. So all of what she is saying is corroborated in this tape is material that Eric Menendez testified to in front of the Lyle Menendez jury. Nothing that he told her separate and apart.
If I could add one thing, I think she would testify that the information provided to her by Eric Menendez during the course of her interviews is consistent with what he told the jury over the course of 9 days of testimony, correct?
Oh, yes. She would say that. I mean, she has said that in her previous testimony. If it's necessary, she'll say it again. But I mean, obviously that's been the thrust of her testimony in the past.
Okay, what is the people's response to this scenario?
Well, it's my understanding then that the Lyle Menendez jury wants Dr. Burgess to testify to all the information about Eric Menendez in front of the Lyle Menendez jury. Is that correct? The offer proof that was just made is what would be in front of the Lyle Menendez jury?
The assumption is there's going to be one examination of this witness and not two. And what she is going to do is go through this tape in an analytical sense to see what is really being said here, with a focus on Eric Menendez. But she is also going to testify to her interpretation of some of the things that Lyle Menendez says here as being corroborative of her opinion as to how the homicides occurred, not her opinion of whether Lyle Menendez was sexually or otherwise abused or whether Eric Menendez was sexually abused. This bears on that portion of her testimony that has to do with self-defense and fear, and not on her evaluation in her role as a sexual abuse evaluator.
All right, all that testimony was before the Eric Menendez jury only as to his fear and all this that motivated him. And each jury is going to be called upon to decide what motivated each defendant.
Well, it's true that her testimony with
Their
respect
respective
was
defendant.
only in front of the Eric Menendez jury, but obviously Eric Menendez's testimony in that respect was in front of both.
Your Honor, Ms. Abramson just said that one of the things she's going to ask the expert is what is really being said in this tape, and when people are going to object to that kind of opinion as being a proper opinion. In fact, much of the offer of proof, I think, the people will be objecting to as a proper opinion. But more importantly, the defense had the opportunity to present this witness in front of the Lyle Menendez jury as to case-specific statements of the defendants they chose not to. They now are choosing to present it, and I don't think that I don't think they're entitled to pick and choose that way. Moreover, I think that the cross-examination of Dr. Burgess, what I would ask then is if this is to be permitted, that I be able to read in the prior recorded testimony of the cross-examination of Dr. Burgess that was done, the direct and cross-examination of Dr. Burgess that was done in front of the Eric Menendez jury only, so that the Lyle Menendez jury would have the full benefit of seeing the testing that was done of Dr. Burgess's credibility and opinions. But I also think that the defense has had the benefit of having Dr. Conte comment on the tape, and first of all, I don't understand why Dr. Conte didn't testify in front of the Eric Menendez jury, but they've already had the benefit of that, and I don't know why. I mean, how many experts do they get to try to explain away the tape?
All right, what I'm going to do is this. The witness, Burgess, was called to testify before the Eric Menendez jury on the issues that are now going to be brought before the jury in her additional testimony. The offer of proof encompasses the entirety of her testimony before the Eric Menendez jury, which incorporates at least 2 days of extensive examination detailing information that she had derived from interviews with the defendant Eric Menendez and other family members, and how she characterized that. And that information could only be before the Eric Menendez jury, because her testimony here is going to, as the offer has been made, one where she will be asked to express opinions as to whether those opinions have changed because of hearing or now considering the December 11th tape. And that is totally irrelevant to what has been presented to the Lyle Menendez jury. They didn't hear that. Her opinions in that regard are totally irrelevant. Much of her characterizations, if legally admissible, of what transpired during the December 11th conversation, again, is based on what she's testified about before the Eric Menendez jury, and it would be confusing and misleading to then have her testify before the Lyle Menendez jury on those subjects. It just would be out of context and would make no sense whatsoever. And again, this was a situation where the defense had the opportunity to call her testify before the Lyle Menendez jury at the time she was here to testify about those matters and chose not to do so. I don't agree that the defense had no choice in that matter. That was a tactical decision that the defense made as to how to proceed. They made that election. And I don't think the argument is a valid one that since the defense hasn't rested, they have the opportunity now to recall a witness to duplicate the testimony that's already been given before the other jury. That could have been presented to both juries. However, to the extent that any of her opinions might be have impact by way of or have been impacted by the December 11th tape, opinions that she has testified about before the Lyle Menendez jury, then certainly those things can be brought before the Lyle Menendez jury. I don't see precisely how that could occur. She's testified before the Lyle Menendez jury about the general fright reactions of fear and crime scene analysis as to what, if anything, derived from that December 11th tape would cause her to change those basic opinions. Would be unclear to me, but that would be the area that you could pursue before the Lyle Menendez jury, since it's new material that would be something that could be brought out. But I don't see how this whole area that dealing with analysis of Eric Menendez, his psychology and his reaction to fear and everything else could now possibly be brought before the Lyle Menendez jury.
And that's based on a waiver concept, that because we didn't call her at the point in time when she was offered in the Eric Menendez jury, that we cannot call her now.
Well, I'm saying it's an analysis under Section 352 of the Evidence Code. You had the time and opportunity to do that, and you didn't do it.
I need to consult with counsel because there's another area, the very brief area that Dr. Burgess is going to testify about, a particular area of her expertise that I want to inform them about, because I think they could then make an offer of proof to allow that particular area of expertise to be put before the Lyle Menendez jury. If we could just have a few moments.
Well, I really want to get going here, so one way or another, this tape has to be played before the Eric Menendez jury, before the Lyle Menendez jury comes back. So they're due back at 11, so let's not take...
No, I just need a few minutes to give them the outline of what the nature of that testimony would be so they're in a position to make an offer of proof. I don't really feel comfortable arguing Lyle Menendez's position. I don't think that's appropriate, but I think they can if I tell them what it is.
All right, how long do you need?
Like 5 minutes.
All right, 5 minutes, then we'll resume, but I really want to get going here.
Could we address another issue very quickly?
Yes.
I spoke with Mrs. Bazanich this morning about scheduling, and what I would like to propose, and she has no objection to it, is that we handle the testimony of Lyle Menendez in a manner similar to the agreement that was made about Dr. Vickery. They have Dr. Ozil on the rebuttal witness list. And so if he's going to testify, then I would want to call Lyle Menendez after he testifies. If they change their mind and do not put him on, then I would still request the ability to put him on, just to see arrangement we made with Dr. Vickery and their uncertainty whether they were going to call Dr. Ferriston and Dr. F. And Mrs. Bazanich indicated she had no objection to that.
That's correct. I will not make any kind of objection based upon improper rebuttal.
Okay.
Your Honor, might we be apprised of this new area of expertise that Dr. Burgess is going to testify to?
Oh, it's not very complicated. It's the fact that what she teaches basically is how to conduct therapy. She teaches and trains therapists, and there is a protocol.
I mean, how to do a therapy session, and
Yeah, what a therapist is supposed to do in a therapy session and what they're
certainly
supposed to.
that could be before both juries.
That was the area that I wanted to.
If there is an area that relates to this witness's examination before the Lyle Menendez jury that has been affected by the December 11th tape, then that would also be permissible. But you'll have to evaluate it with that in mind.
Now, this sort of knocks my outline of what I'm going to do with this witness off kilter, because I was going to start with the therapy part, with the teaching and training and what's supposed to be in a therapy session or examination with this. And I might need to do a tiny bit of repetition of that. I have to do a little bit of that in front of my jury before they hear the tape. So I'm asking the court's permission to do a little repetition of that in front of the Lyle Menendez jury so that they can have the benefit of that.
Well, can't you just start playing the tape and before it's played, just have her ask her a question such as the way the therapy or the session is reflected on this video, this audio tape, is that what you would approve of, or something along those lines. So just generally one or two questions, and then
Well, there's
play
two
it.
things I want to do about the tape that would not be in front of the Lyle Menendez jury based on your ruling now anyway before I play the tape. I don't want to just cold cock them with this tape. It's, it's a difficult piece of evidence. But I'm not planning on taking more than about 20 minutes before I play the tape. But I'll soft pedal the training therapy part and get back to that later.
Correct, just for clarification, Dr. Burgess will be allowed to testify in front of the Lyle Menendez jury that the tape doesn't change her opinion about the pregnancy analysis. Is that correct?
If they can figure out a way that's relevant to that issue, yes.
All right.
I need a few
And then
minutes.
the scope of cross-examination will be determined by the way they handle it on direct, correct?
Of course.